Hi friends, today we are going to discuss about Consumer Protection Act and Healthcare Services. I am Dr. Suresh Padmat, Professor of Psychiatry, Head of Telemedicine Center, Head of Forensic Psychiatry Unit at NIMANS, Bangalore. Before I start my presentation, I would like to have a disclaimer. This presentation is for academic purpose only. If you want to have a legal opinion, please do contact an advocate. This presentation is not for legal opinion. Please do remember that. Conflict of interest? None. Consumer Protection Act of 2019 was passed on 9th of August 2019, approximately 1 year back, but it came into force on 28th July 2020. This presentation is focusing on Medical Profession and Consumer Protection Act 2019. What is in there for doctors? Do they come under the ambit of Consumer Protection Act? That is what we are going to answer in this presentation. Please do remember, this presentation has both argument and counter-argument. The argument that it is not there in the Consumer Protection Act because nowhere in the legislation it mentions about health, medicine, medical, healthcare services under the definition of services. If you look at the whole legislation, hardly in one place it is mentioned about medicine and health. Otherwise, nowhere it is mentioned. Hence, it's not there. At the same time, in the initial draft, when the bill was prepared, the healthcare was mentioned under the definition of services. But subsequently, the doctors lobbied with the government and requested the government to remove the healthcare from the definition of services. Of course, in the subsequent draft, the healthcare was removed from the definition of services. This is basically the government bid to pacify the medical fraternity, which had expressed the apprehension over the law being used adversely against the profession. So most probably the government accepted it. Hence, these are the two strong arguments telling that it's not been defined, it's not there either mentioned or excluded. So the doctors feel that they are out of the Consumer Protection Act. These are the arguments, and they are happy they're not under the Consumer Protection Act. But however, with the equal force, there is a counter-arguments. Counter-argument number one, service. Let us look at the definition of service. Service means service of any description which is made available to the potential users and includes but not limited. So please do remember this emphasis. Not limited to. The provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, telecom, boarding or lodging or both, housing, construction, entertainment, amusement, or the purviewing of news or other information. So please do remember, though it has mentioned in this definition a lot of services, earlier healthcare was mentioned, but it is not there. But however, but not limited to gives a wider scope to be included, but does not include the rendering of any services free of charge or under a contract of personal services. Coming to this, please do remember the counter argument number two. It has excluded only two things: free services, that is, services rendered free of charge. They are excluded under the Consumer Act, or contract of personal services. That means if you have a cook at your house and you are paying salary for her, you cannot put a consumer case on her because you are the master and she is the servant. So there is no any consumer relationship here. She is not the service provider and consumer. It is a master-slave relationship. So in that, it is excluded. So coming to the counter-argument number three, the apex court. If you look at the World Consumer Protection Act of 1986, there also the healthcare profession was neither included or excluded. However, in 1995, the Supreme Court judgment in a case of IMA versus V.P.Shanta, it's a landmark judgment. In this, the Supreme Court was very, very clear, and it clearly articulated medical profession comes within the ambit of service, and it is in the definition of Consumer Protection Act. Since then, there are many judgments which have come in to the Supreme Court under the Consumer Protection Act. So it is there. whether the term exists under the law or not, that is under the legislation or not. A consumer who has been offered a service for a considerate has a right to approach the court if there is sufficient evidence that there is a breach of duty or medical negligence, and consumer has all the right to move to the commission. That's the way it goes. And also, the Apex Court clearly said that the relationship between the patient and the medical profession is as a contractual in nature. Remember that contractual word because I'm going to repeat that again. Again, coming to the one more definition, counter argument number 4, deficiency. We talked about service, now we're going to talk about the deficiency. Deficiency means any fault, imperfection, shortcomings, or inadequacy in quality, nature, and manner of performance which is required to be maintained by or under any law for the time being in force. But however, now you keep this point very clear, has been undertaken to be performed by a person in pursuance of a contract. So that means the earlier Supreme Court judgment clearly said that doctor and the consumer is a contractual in nature. So now it's a contract and it is a part of the Consumer Protection Act 2019. At the same time, the deficiency is also been clearly said that any act of negligence, omission, or commission by which a person causes loss or injury to the consumer, it's farewell. At the same time, deliberately withholding relevant information by such person to the consumer. The doctor do not give information, like for informed consent. The deficiency clear comes into the picture here also. So it all fits into the Consumer Protection Act under the argument number 4. Argument number 5. Please look into the Consumer Protection Act Mediation Rules 2020. Under the rule number 4, it's very clearly has written that medical negligence related grievous injury or death should not be sent for mediation. Why it is so? Because medical negligence come under the ambit of Consumer Protection Act, my dear friends. The last argument, coming to the definition of consumer. See, the definition of consumer has become wide here in this legislation. It has two important things: buying any goods. Of course, the doctor may not provide goods, but the consumer is also who hires or avails any services, which includes both offline and online. Transaction through electronic means or by teleshopping or direct selling or multi-level marketing. And this clearly clarifies the scope of CPA 2019. My dear friends, there is no doubt the counter argument is also very, very vehemently, clearly says that because of the Supreme Court judgment, and many judgments are there which clearly says the doctor and patient relationship is contractual in nature. And that is very clearly spelled out in Consumer Protection Act of 2019. My dear friends, to conclude, though the doctors are arguing that they do not come under the ambit of Consumer Protection Act because of the confusion that the health services have been removed from the definition of services, but however, the counter arguments are also equally impactful. This can be clearly by only two means. One, the legislation should be amended clearly telling that the healthcare services are excluded, or else the Apex Court should interpret the law by telling that healthcare is excluded. Till then, we are on board, my dear friends. Friends, if you like this video, please do subscribe, comment, and share this video. Thank you very much. Stay safe.